subject to the Nareda injunction, but otherwise you can continue to trade. Now, I've read the submission, and I've gone back to look at the decree and to look at the acting Chief Justice's order. Is there anything else you'd like to say on that subject that isn't already said in your written submission?
I appreciate the indulgence you've already shown me. I don't want to try your patience and repeat what we've included there. I guess just two things I would like to add, Your Honor.
Yes.
Number one is, and it will tie into your question. We don't agree that reverting to the committee is, as it was characterized in the claimant's skeletal threat. We believe that the structure of the decree provides that the parties revert to the committee and actually present their pleas to the committee. And so, as for our stated intention to present our case to the committee, and which would include whether we believe that the court is applying the decree or the order that was issued by the acting Chief Justice of the Court of Cassation properly, is not it's done out of respect. We have no intention of threatening anybody. It is something which we feel is in compliance or in line with the way that the law is supposed to operate. And I would just add that I believe the claimant feels the same way because they've already requested the opportunity to make submissions to the committee. As far as we believe that the drawing a distinction between the cessation of trading order and the rest of the order that arose out of your judgment is, with respect, somewhat artificial. Both of those orders arose out of the same judgment. They were all based on the same considerations, and they were all, both of them, based on circumstances which now are called into question, which was the lack of definition as to which court would look at the merits of the annulment challenge. So we believe they are related. In fact, they're based on the confusion which has arisen between the courts as to which court is the proper court to hear the annulment challenge, not a defense to the enforcement, but the annulment challenge. So, therefore, we think the distinction drawn between the two parts of your judgment would be a technical and somewhat artificial distinction to draw.
Just help me. Which two parts do you have in mind?
Well, you've ordered the cessation of trading,
yes,
to take effect, which did take effect.
Yes.
And you've ordered winding up of the company and the appointment of a liquidator.
Yes.
That was stayed.
Yeah.
Those two parts are being treated differently because the cessation of trading order was, in fact, an order that Your Honor ordered. The other one was stayed. It was also an order, but was stayed.
Yes.
But we think they distinguishing between the two of them, given as they arose out of exactly the same circumstances and within exactly the same judgment, would be somewhat artificial.
Yes,
and we
I see.
think that's what the committee had in mind.
All right. Thank you very much.
Whether you want me to come back on that depends on where your lordship is currently minded to land on this position.
Well, I'm going to, towards the end of this proceeding, I'm going to issue a short ruling on this important submission that the defendant makes. And so, at some appropriate moment, I'd like to hear you in response to the submission that Mr. Baderi has made. I think what we can do is to park that for the moment and then turn to the question of the undertaking, the continuation of the undertaking. And perhaps I ought to say now what I'm minded to order.
Yes.
I'm going to amend the cessation of trading order to allow for the payment of salaries and staff expenses on a prorated basis, the precise sum to be agreed between the parties. In principle, I am minded to make a similar amendment in respect of the general and administrative expenses, but I decline to do so until the further information that I've requested has been provided. And I would propose to allow liberty to apply in respect of that line, and the whole thing to be done in writing only, without any hearing. So what the defendant would have to do would be to answer the questions that I've raised in a witness statement, and to assist the court to proffer a prorated sum for 7 weeks rather than down to the end of December. So in other words, to inform the court as to what the individual items are encompassed by line 2 and what the the periodic sums are that will fall due during this 7-week period, and in particular to inform the court as to the question of rental of premises, how much rent, who the landlords are, and what activity is conducted within those premises. And I will deal with that simply in writing, and as I've said, I'm minded to allow a figure. What it is will depend upon the information I'm provided with, and I will issue a written ruling and a written amended order. I am not minded to make any further amendment to the cessation of business order, but I will continue the liberty to apply which I granted when the orders were made last Wednesday, so that if any matter emerges which urgently calls into question the feasibility of the defendant, then they may apply on notice, and the court will deal with it as expeditiously as possible. It may not be myself, but once we're out of the Eid holiday and the court is continuing to function in a normal way, one would expect that an urgent application under the liberty to apply could be dealt with.
Yes.
So let's then turn to your submission. You must make it on the basis that the defendant, although it maintains that there are doubts as to the efficacy of a cross-undertaking in damages, the defendant would require a cross-undertaking in damages to continue, notwithstanding these amendments which are going to be made to the cessation order. Do I assume correctly that that would be your position, Mr. Baderi? Or, I mean, I only want to hear, Mr. Brannigan, if you require a cross-undertaking damages. If you don't require a cross-undertaking damages, then I'm not going to order it. No, you require it. That's what I thought you'd say. So
I suppose there are...
Excuse me.
Sorry.
Yeah. Notwithstanding the disagreement we have expressed as to the application of the decree itself.
Yes. Yes, without prejudice.
Yes, without prejudice.
Yes, I understand. Yeah.
Yes, but I'd understood my friend. We can do it on the same basis. My lord, the points are relatively short. Given the order your lordship is minded to make, and I'm not going to seek to dissuade you from that order, in fact, the risk which is posed to the other side is very minimal indeed. Because not only is your lordship now minded to grant them that which they need on the face of the information before us to continue trading, but my lord has also given them liberty to apply in case there is anything else that emerges. Given that, we say there is no real appreciable risk at all now of the defendant being prejudiced by the order which your lordship has made. If an issue arises where they say, well, actually, we know you've ordered the first 2 of the line items, but we want you to order item 4, 5 or 6 or whatever it is, your lordship could at that point take the view, well, okay, I'm minded to allow them to only prevent that if there is an undertaking as to damages. But on the basis of where we currently are, my lord, the position is that the other side have got, on the face of the orders made by this court to date, the benefit of 1 billion dirhams, which is owed to us. They have all the protection they might need in the world in respect of any cessation of trading. The effect of the decree is not to wipe like a blackboard the previous orders made by this court, but to suspend further enforcement of those orders. And this court has recognised and found that we are owed 1 billion dirhams. That provides the other side with anything they need in terms of assuaging concerns. So the first point is that there is no appreciable risk to the other side if you make the order which your lordship is minded to make. The second point is that any minimal risk there must be set against the fact that they, on the face of your lordship's orders to date and the orders of this court to date, owe us 1 billion dirhams. And the third point is this, my lord, it's a point I made on the last occasion and didn't find favour, so I would labour it. But we say that, contrary to what the other side say, the correct approach now is to hold the ring on a status quo basis, to try and maintain the current status quo whilst this newly constituted tribunal look at the question which the other side have asked it. And we say the correct way to maintain that status quo is the orders that your lordship is minded to make, but without asking us to do something new and different, which is to put in an undertaking as to damages.
Yes. Thank you.
So those are my 3
Thank you
suggestions.
very much.
May I reply?
Yes, certainly.
Just to make the point that given the decree and given the work that the committee is now to undertake, it must at least be considered possible that the award will be set aside and annulled. If that is the case, then the premise on which the comments have just been made falls away. And our concern with respect to the undertaking was that you have a combination of a company, a claimant, which I could be corrected, but appears to be non-operational and hasn't been operational for quite a few years. I would doubt that it has any assets whatsoever, at least from appearances, and it would rely entirely on its parent to satisfy any undertaking that it may give. That parent appears to be, from what's available to the public, in serious financial problems and may be on the verge of bankruptcy.
Yes?
That's the reason we requested, in light of these considerations, some evidence that an undertaking would actually be something that could be complied with one way or the other. But we feel uncomfortable that it in fact could be complied with, given the circumstances which we have noted. I think that's what I wanted to say.
Thank you very much.
Yes, I did have one final point, but it doesn't relate to what you've just been discussing.
Well, let me know what it is.
Yes, that has to do with two additional matters. The company, the defendant, is a special purpose company. It doesn't have its money is generated by the sale of units in that building. It has some remaining assets left, which payments that are listed here and others are based on receiving funds from. As things stand now, it's unable to make any further sales of those units. It would like the ability to do so, and it would like the ability, for example, with respect to the Emirates National Bank transaction, to undertake a transaction of that nature, but more fundamentally to be able to sell the property that's remaining in the building. That property is much it's more advantageous to sell it under the circumstances in which we are now than by a liquidator who would assume get rid of it as fast as it could. So that's a concern to us because the company is not flush with money, as you can see, and payments that it could potentially make depend on being able to sell those properties. And the last point has to do with the involvement of the claimant's counsel with the DIFC property registry. We've presented some evidence of that in the form of an email from the registry to the defendant, indicating that any transfer of title of any unit in the building would require a no objection letter from Clyde & Co. We've sought to understand from the registry why they've taken this position, because it didn't seem to be pursuant to the freezing order, but we've not been able to get an answer on that. And it's something that we think should be clarified, because if the freezing order is observed and the cessation of trading order, which Your Honor is continuing, is observed, that shouldn't also impact the ability of tenants or owners of property in the building to obtain their titles if they're entitled to do that.
Well, just dealing with that last point, the agenda for this adjourned hearing was set last week, and the point you've just raised, although potentially it may well be a matter to be drawn to the attention of the court and to request an order, this hearing was set, and the time to be devoted to it was set on the basis that we would deal with the other matters. And I've looked at what you've had to say about that, and I can see the potential for evidence to pass from one side to the other. And we're not in a position to deal with that. You've produced the email, but given how this litigation has been conducted in the past, there is bound to be a response and a wish to serve evidence to the contrary. And I'm afraid we simply can't deal with that matter today. But under the Morava injunction, if you don't have an express liberty to apply, you certainly have an implied liberty to apply. And if you're not satisfied with the outcome of any further representations you make to the claimants, well, then you have your liberty to apply. But I can't deal with it today. The defendant submits that any order of this court requiring it to cease trading is unfair and runs contrary to the intention of Decree number 19 of 2016 and the order of the ACJ of the Court of Cassation, who is the president of the judicial body established by that decree. I will call that order the ACJ's order. The order that the court made on the 16th of June was premised on the basis that there no longer existed an annulment ground that had a real prospect of success. The Dubai Court of Appeal had rejected the defendant's appeal from the decision of the Court of First Instance. There was a debate between the court and counsel for the defendant at the hearing of the petition to wind up as to what the consequence would be if the Court of Appeal dismissed the defendant's appeal. Counsel for the defendant very properly, frankly, accepted that that would be a situation which the winding up court would have to take careful account of. The court raised the question of an appeal to the Court of Cassation, but no submissions were made as to whether an appeal lay or what the grounds of such an appeal would be. Accordingly, come the 16th of June, the court concluded that the decision of the Court of Appeal meant that there was now no outstanding case for annulment of sufficient arguability to stand in the way of a winding up order. The court gave its reasons for concluding that the claimant was entitled to a winding up order as distinct from some other form of execution. The court expressed concern about how certain matters had proceeded and expressed the view that the sooner a liquidator, who would be an officer of the court, took control of the management of the defendant, the better. It was in the light of those observations that the court made its supplementary order that the defendant should cease trading. A 7-day stay of the winding up order was granted, allowing for an application to the Court of Appeal to extend the stay pending an appeal. And given that 7-day interregnum, the court concluded that justice required that there be a cessation of trading, so that the position was held enabling a winding up of the company to proceed after the 7-day period with the same outcome as if the winding up order had been of immediate effect. The cessation of trading order was accordingly a subsidiary order of the court designed to ensure that when the court's judgment came to be enforced, justice would be secured. I decline to accept the defendant's submission that the cessation of trading order is inconsistent with the decree number 19 of 2016 and the ACJ's order. In my judgment, the suspension of proceedings contemplated by the decree and the ACJ's order does not require this court to discharge subsidiary orders so designed that upon the ultimate enforcement of a final judgment, justice will be done. As I have already said, the ultimate enforcement of this court's judgment enforcing the award was the granting of a winding up order. That order has been stayed in the light of the decree and the ACJ's order. The cessation of trading order and the Moreva injunction were designed to hold the ring so that if the final enforcement order came into effect, it would secure justice to the claimant. I cannot accept that the ACJ's order and the effect of the decree is to require the DIFC court to rescind orders that are subsidiary in nature, are not final enforcement orders, and are designed on the basis of all the material before the court to do justice. The defendant has made an application without prejudice to its principal submission as to the effect of the decree for the amendment of the cessation of trading order to ensure its continued viability whilst the question of which court has jurisdiction is pending before the committee established under the decree. The court will order an amendment of the cessation of trading order to allow for the payment of salaries and staff expenses for the period henceforward to the 11th of August, which marks the end of the 30-day period in which the committee must make its determination as to jurisdiction. The precise figure is to be agreed between the parties with liberty to apply if there's any disagreement. The court is also minded to amend the cessation of trading order to allow for the payment of general and administrative expenses, but declines to do so at the moment because further information is required before there can be a final determination as to the amount to be allowed. The defendant will have a liberty to provide the further information that has been identified by the court in writing, both to the served on the claimant and the court. The defendant will be permitted to make a short submission in writing. If so advised, the defendant may serve short reply submissions, and the whole matter will be dealt with on the papers with a written ruling. I should mention that the further information the court requires must be verified in a signed written statement signed by a proper officer of the defendant company. I have considered the other items that were put before the court. In support of the application for further amendments to the cessation of trading order, I am not satisfied that these other matters throw the viability of the defendant into serious doubt for the period that remains expired of the 30-day working day period for the decision of the committee. That the liberty to apply on notice, which was granted after the hearing last Wednesday, will continue, so that if anything arises which urgently puts in doubt the viability of the company over the period in question, the defendant may apply on notice to the claimants, to the court. I turn now to the question as to whether the claimants should be required to give a cross undertaking in respect of the amended cessation of trading order. I explained at the last hearing that given the issuance of the decree and the service of the ACJ's order, this was not a situation which required simply the maintenance of the status quo as represented by the orders made on the 16th of June. Under those orders, there was to be a cessation of trading for 7 days. The relevant period is now considerably longer, and the court must recognize that there is a possibility that an order will be made by the committee in respect of jurisdiction that could ultimately lead to the annulment of the award. defendant's argument for annulment